Okay, but Dr. Rahul Pandit, I was just trying to research how many people in India have actually gone about making a living will. I found 42 in Thrissur. I found a doctor in Bombay, another doctor somewhere else in the country, and I couldn't find any more. So clearly there is either a lack of awareness or a certain hesitation, because it will be construed as a bit of manhusiyat. But just coming back to the Court of India, our constitution gives us the right to die. We have the option of making a living will as well. But with the guidelines that I've seen Karnataka put out, it seems to give too much power to the doctor in the hospital. It's the treating doctor who has to first approve, then the hospital will set up 2 medical boards, then it will go to a magistrate, which ultimately will report to the High Court. In Western countries, you have full medical autonomy. In India, it seems much depends on what the doctor decides.
No, it's not like that. I think it's a very important decision which the Honorable Supreme Court of India gave. And the Karnataka government is one of the first states who has actually gone ahead and given directives how to form a secondary board. There has been an order to a similar record by the government of Maharashtra as well, by the Director of Medical Education and Research to the medical colleges as well. So what the judgment says is that if there is a patient who is there in the intensive care or in the hospital who is terminally ill and is unlikely to benefit from any medical intervention, in that case, keeping on continuing the medical intervention is not going to be helpful. So if there is an agreement between the treating doctor and the family as well, then the doctor actually says that we can form a medical board. Medical board consists of the treating doctor, the primary medical board consists of the treating doctor and 2 independent doctors who are not connected with the case, but who have got relevant 5 years experience. They come, they would give their opinion, preferably within 48 hours. They would speak with the family, and if the family as well as the doctors agree to the condition, then a secondary medical board is formed. The secondary medical board should have 1 member who is appointed by the district health officer or by the director of health services, somebody who actually appoints a brainstem death committee, which is a very well formed process for all the states across the country. So one of them has to be the one appointed from there, and then 2 again independent ones. So this actually gives a patient 6 various opinions from 6 independent doctors. So it's a process which actually allows the patients to have multiple opinions. It allows the family to have an opinion, and it really tells everybody that yes, the condition seems to be futile and it is not going to help this terminally ill patient, so that a withdrawal of therapy, of life-sustaining therapy, perhaps could be initiated. But at all times, family is, of course, has to consent for it as well.
But Dr. Rahul, that exactly is my point. I have medical autonomy. I have decided that if a situation arises where you need to put me on ventilator support, I don't want it. Let me die. Now you're telling me that there are 6 doctors whose opinion also matters. Now,
no, I don't.
Doctors may decide nahi chance hai. I may have made up my mind that I will not go on ventilator support. So what happens if I have decided, if I've made a living will, where is my medical autonomy if 6 doctors are also deciding on my behalf?
So everything which happens in a hospital happens with the consent. The situation which I mentioned to you is the one where there is no living will which has been produced, and the patient is not in a capacity to give their wishes. If the patient already is in a capacity to give their wishes and has got complete autonomy of their own medical thing, they obviously will not seek that kind of a treatment. They may refuse to be put on a ventilator, or they may refuse to be put on a life-sustaining therapy. That's a completely different scenario. Nobody can be forced to actually undergo a treatment, or nobody can be forced to even go to a hospital. That's perfectly fine as long as they are understanding it. But that's not what the gist of the judgment was. Gist of the judgment was to protect the patient at all times.